To the second day of the Girona Oxford meeting. Now it's the turn of the PhD researchers from Oxford. Well, Andrea is a great friend of ours, in addition to be a PhD researcher in Oxford. Graduated in philosophy with Evandro Agazzi, a famous logician in Genoa, and also studied a PhD course in Genoa in legal philosophy with Guastini and Pierluigi Chiassoni. Well, Andrea, we're from you.
So today I would like to discuss with you the relationship between the idea of sovereignty and some problems related to the continuity of law or the continuity of a legal order. So the idea of sovereignty is commonly explained by referring to the supreme power within a given political community. And we can take as a standard explanation of sovereignty this kind of idea, which was quite common since the 16th century. We can think as a paradigm the definition of sovereignty given by Jean Bodin, who defined sovereignty as the absolute and perpetual power of a commonwealth, which the Latins call majestas. Now, for the purposes of this paper, it's not necessary to discuss this idea of majestas as related to sovereignty from an history of ideas perspective. But nonetheless, I would like to underline that this idea of majestas implies the idea of relationship of some powers which are major or higher than others. And the other two adjectives used in this definition qualify this kind of power as absolute and perpetual. So let's keep in mind this idea of no limits for sovereign power and the idea of time. And the fact that this power is perpetual means that it's not just one time as a spot we have this explosion of power, but it's something which is constant within a given political community. And since 16th century, because of European modern history and the theory of state which was developed in relation to the modern experience of the national state, explaining the idea of sovereignty usually entails regarding the state as the matrix for this kind of power, since it is the state that is considered to be the supreme power in any given community. Yet explaining the idea of sovereignty in terms of the absolute and perpetual power of the state is problematic, at least because it is not clear if the power at issue in this kind of explanation is a de jure or a de facto power. Sometimes in this explanation we have a confusion of these two kinds of powers. And in fact, if state power is reduced to the factual ability of the state to secure law and order by means of the monopoly of the use of force, it seems that sovereignty would merely describe a state of affairs, a fact in the world, the fact that a given subject holds the ultimate power within a given community. Several theories of law and the state have indeed tried to explain not only the existence of a political community, but also the existence of a legal order as a function of the existence of a factual sovereign power. So the problem I intend to tackle in this paper, in this discussion with you, is whether or not the idea of sovereignty actually can be explained merely in terms of a de facto power. And in order to do so, I will take into account the idea of sovereignty in relation to political communities and legal orders under the assumption that these two social constructions are correlative, political communities and legal orders. But before proceeding any further in this discussion, in questioning if sovereignty simply denotes the factual power of the sovereign, two clarifications are required. First, even though I believe that the concept of state plays a crucial role in the understanding of sovereignty, I do not think that the only possible framework for the idea of sovereignty is provided by the relationship between a political community and a state legal order. And secondly, it is necessary to distinguish between a given political community as a subject of international law and the government, including the organs of government of that community. So in this paper, I will refer, well, in the explanation, I will refer to political communities and to governments, but well, in the paper I use state with capital S to refer to governments and state, normal state, the word, to refer to political communities. And this last distinction gives a way to reframe the quite useful distinction between internal and external sovereignty. So the former, the internal sovereignty, can be conceived of as the ruling power exercised by the state, by the government within a political community, whereas the external sovereignty can be conceived of as the autonomy of a state, of a political community, understood as a closed system that can be related to other states, so to other separated political communities. Well, obviously, in particular circumstances, it might be possible for a state, for a government, to divide all its powers among different and equal holders, controlling and limiting one another. And in this case, it seems impossible to speak about a single internal sovereign within a given state. Nonetheless, using this distinction, it's possible to recognize that the political community, this given political community, as a subject of international law, is still sovereign in the sense of external sovereignty. So I suggest considering the idea of sovereignty, at least preliminary, with regard to another distinction between legal and political sovereignty, which is related to the main discussion, which is the relationship between the de facto and the jure power. So this distinction points at two different kinds of power commonly ascribed to the sovereign: legal power and political power. So from a legal point of view, sovereignty can be thought of as the possibility of exercising complete lawmaking power with no legal restrictions. This recalls the idea of absolute power. Whereas from a political point of view, sovereignty can be thought of as the possibility of exercising the kind of supreme power that ultimately affects people's conduct. What is common to both these conceptions of sovereignty is the idea of the existence of a power which is not limited by any higher or coordinate powers. And so here again we can think about the definition given by Jean Baudin. And even though I consider this potential condition of sovereignty, that the sovereign power cannot be limited by other powers, I will discuss this later, and I would now like to focus attention on the distinction between internal and external sovereignty, discussing some uses of the term in legal discourse. And basically, the word sovereignty is used in legal discourse in two main contexts: constitutional law and institutional law. And if we look at the use of the term sovereignty in the internal aspect, in the constitutional law, it's related to the foundation of the legal order of the political community we are analyzing. And in this perspective, it's interesting to read the critique moved by Hart to John Austin, when Hart is discussing the Austin's theory of law, in which sovereignty plays a crucial role. And Hart is discussing a theory of law, and in discussing this theory of law, he gives some interesting thought about the idea of sovereignty. Well, obviously, you know very well that according to Austin's theory, in order to define a society as political and independent, I'm quoting Austin, the generality or bulk of its member must be in a habit of obedience to a certain and common superior. And this person, which is the sovereign, this person or this certain body of person must not be habitually obedient to a certain person or body. As you know, Hart analyzed this theory and he criticized the idea of an habit of obedience, stressing the importance of a rule, a kind of rule of recognition, instead of merely the habit, and he distinguished between a norm and a habit of obedience. And in discussing the idea of sovereignty, Hart point out at some problems in constitutional law which are related to the legal order of a political community, but also to the idea of sovereignty as related to its external aspect, so as related to the political community as a subject of international law. And what is interesting is that Hart, as many other theorists, recognize in the word sovereignty terms which brings this idea of relationship of a relationship between persons, in this case sovereign and subjects, and I'm quoting Hart now when he says, whenever the word sovereignty appears in jurisprudence, there is a tendency to associate with it the idea of a person above the law, whose word is law for his inferiors or subject. And Hart considers this idea of sovereignty seductive because it's an easy way in his perspective to explain law, and this is what Austin did. And I think that the use of sovereignty is also seductive because it has been used in different contexts, and not only in the constitutional law discourse but also in the international law discourse as a rhetorical device. So many times sovereignty has not been used as a concept in a theory of law or in a theory of the state, but simply to bring about some normative claims about the division or the organization of political power. This is particularly clear at the international law levels, what many claims, we can take the example of the European Union, but also in general international law, many discussion about, for example, the compulsory jurisdiction of an international court like the ICJ have been challenged by this idea of sovereignty of the state, and all the process related to the European Union had to face this challenge of the defense of many politicians or lawyers of this idea of sovereignty of the state, of the political community, as this total freedom of the state to make treaties, or in any case not to be limited by other powers. And Hart is aware of this distinction between internal and external sovereignty, and in fact he discussed it in the concept of law, problems of sovereignty, in two different chapters. In the chapter 4 when he discussed Austin theory of law, and then in the last chapter of the concept of law when he discussed the idea of international law. And being aware of this distinction between internal and external sovereignty, Hart considered two possible formulations of the problem of sovereignty, which must be separated from this dogmatic or rhetorical use of sovereignty, which in a way is interesting. I mean, obviously that can be analyzed from other disciplines, not from jurisprudence, but what is interesting for a legal analysis of this concept is that when sovereignty is used as a rhetorical device, it's still bringing, I mean, as a normative claim about how we should organize political power of a given political community. It's interesting to see that it enters into the picture when there is a discussion about two possible powers claiming for the higher position in a hierarchy. This is quite clear if we look at the idea of sovereignty in its historical development. This is clear during medieval times, at the beginning of the modern European history, and I'm not going to discuss this today, but I just want to underline that this involves this idea of at least two possible powers which should be put in a certain kind of hierarchical relation. And the two formulations given by Hart of the problem of sovereignty are the following. In constitutional law discourse, the paradigm of sovereignty is conceived of as the supreme legislative normative authority. And whereas in international law discourse, the paradigm of sovereignty is tied to the idea of state autonomy. And in relationship to municipal law, to the internal aspect of sovereignty, the problem can be formulated as the determination of the extent of the supreme legislative authority recognized by the legal order. Whereas in relation to the international law discourse or province of sovereignty, the formulation of this problem is the determination of the maximum area of autonomy enjoyed by the state. And in both cases, this is the main point stressed by Hart, the solution of the problem is possible by examining rules. So here Hart is suggesting a normative idea of sovereignty and not examining facts. And this idea is common to Hart as well as to Kelsen, because Kelsen discusses the problem of sovereignty in different contexts. And one of his first major work is devoted to the discussion of the problem of sovereignty in international law. And again, Kelsen is aware of the problems related to the use of this term. And in the first edition of the Pure Theory of Law, Kelsen says, the theoretical dissolution of the dogma of sovereignty, where the dogma of sovereignty is the principal instrument of imperialistic ideology directed against international law, is one of the most substantial achievements of the pure theory of law. And here Kelsen is thinking about one of the many achievements of his theory. In this case, the achievement is that this theory managed to distinguish between this dogmatic or rhetorical use of sovereignty and the proper problem of sovereignty within a legal analysis. And as you know, according to Kelsen legal theory, sovereignty is not a quality of the state as such, because in Kelsen's theory, there's no dualism between state and law. So basically state denotes the same as the word law, qua legal system. So sovereignty is conceived of as quality of a set of norms. And more precisely, Kelsen conceived of the idea of sovereignty as an hypothesis in legal thinking that a unique legal order has the quality of supremacy and autonomy. And as a consequence, the problem of when a state may be said to be sovereign has been rephrased by Kelsen as the question concerning the psychosociological conditions under which a jurist makes this presupposition. According to Kelsen's theory, recognizing a given legal order as sovereign means presupposing its validity. And it means presupposing the validity of the so-called historical first constitution. And this presupposition is the theoretical move which Kelsen calls Grundnorm. And so in this analysis of sovereignty, sovereignty becomes a quality or a feature of a legal order when this legal order is competing in a way with, or the validity of this legal order is competing with other legal orders, and especially with a higher legal order as international law. And the theory which, in Kelsen's perspective, explain in the best way the idea of sovereignty is the idea of legal discontinuity, which is the idea that the identity of legal order changes when the historical first constitution changes. So Kelsen holds the view that basically when, I'm quoting here from the General Theory of Law and State, it is just the phenomenon of revolution, which is a contra ordinem change of the historical first constitution, which clearly shows the significance of the basic norm. Suppose that a group of individuals attempt to seize power by force in order to remove the legitimate government. If they succeed, if the old order ceases and the new order begins to be efficacious, because the individuals whose behavior the new order regulates actually behave by large in conformity with the new order, then this order is considered as a valid order. But this means that the new basic norm is presupposed. Now, I don't want to discuss here in details Kelsen's theory of sovereignty or of validity, but it's interesting to see again that this idea of sovereignty is related to the category of time, because, well, the idea is that the recognition of the validity of the legal order, or the new legal order, is related to the fact that this legal order is effective, and this is an idea which can be, and this is a fact that can be recognized in time. And then, well, we have the problem of who is recognizing this kind of continuity of the new legal order against the old one. And, well, I'm supporting the thesis that here the role played by judges is what we should look at more than the perspective of the jurist, in the sense that clearly Kelsen is thinking about a legal theory made by a jurist about the idea of sovereignty, which is so the jurist has to recognize the new legal order, and but the fact that the new order is effective relies on the behavior not only of the citizens. I mean, the behavior of the citizens pass through the recognition of the magistrate or the judges. So from a legal point of view, we can take the behavior of the judges as what we should look, and this is also proved by history. If we look at, for example, in the last century, many countries in the Commonwealth that gain independence in more or less violent or revolutionary way. If we look at the revolutions in Pakistan or in Rhodesia, we see that the role played by the courts made a difference in the recognition of the new legal order, the new government in relationship to the old one. And I don't want to go into the discussion of the problem of sovereignty in relation to its external aspect, but I would like to focus on some points related to the internal aspect of sovereignty and then go to the conclusion. So, well, in the internal aspect of sovereignty, I think that it's interesting to see how Hart discusses the theory of Austin, because he has this idea first of a normative idea of sovereignty, and again, through this relation to norms, he stressed the category of time as an important category to understand what sovereignty is. But what is not clear enough, in my view, is the qualification of the power, because obviously here in this case we're talking about power conferring rules. And what I'm trying to explain in this work is that when we think about the power as sovereign, we are implying the idea of a relationship between this power with another power. So when we qualify a power as sovereign, we are actually qualifying this power as sovereign because it's in a relationship, in a hierarchical relationship with another power. And this kind of relationship can be understood as, well, taking this idea of hierarchy from Guastini, as a powers hierarchy. And each normative power, says, is said by Guastini, is created by a power conferring rule enacted by another normative power. The normative power, P1, which enacted the power conferring rules, is superior to the power conferred, P2, in the sense that the second power is grounded on the first one and draws its legitimacy from it. One could say that there is a structural hierarchy between P1 and P2. As a consequence, the rules enacted by P1 are higher ranked than the rules enacted by P2. So what I'm trying to suggest here is, on the one hand, that the definition of, or the explanation of sovereignty as simply a kind of power is not enough. It's not enough precise. We should make explicit the fact that every time a given power is recognized as sovereign, we are actually qualifying a relationship between two powers. Then now I'm only thinking about the internal aspect of sovereignty because I think the main problem in discussing the idea of sovereignty is whether or not we can reach an explanation which is valid for both the levels, the municipal law, the constitutional law level, and the international law level. This is not a problem which I address in this paper, and I don't know whether or not it's possible. Maybe we just have two different concepts of sovereignty, and we should provide two different explanations of these two concepts. But what is in a way common to these two concepts is the idea of a continuity of the power, which is mirroring the continuity of the legal order, which contains the rule by which we qualified that power as sovereign. And this is in a way, this is maybe a possible way to understand the two concepts of sovereignty as related. And it should be a way to understand in both the cases the qualification of a power as normative and not as simply a mere de facto power. But I would like to discuss this problem with you. Thanks.